Hello and welcome to the podcast. I'm Dean Tellone and you're listening to Episode 2, Estate Planning 101, How to Protect Your Wealth for Generations. In today's episode, we're diving into a topic that often gets put off, estate planning. You might be thinking, do I really need an estate plan? Or isn't that only for the ultra wealthy? The truth is, estate planning is crucial for everyone who wants to preserve what they've earned and ensure it passes smoothly to their loved ones. In fact, studies show that fewer than 1 in 3 Americans have a will or any estate planning documents, meaning most people are leaving the fate of their wealth up to default laws and courts. Today, we'll talk about why that's a risky gamble and how you can do better. Our goal is to make estate planning concepts accessible and easy to understand. We'll cover why estate planning matters for preserving wealth across generations, walk through key tools like wills, trusts, and tax-efficient strategies, and how they can help you avoid probate court, highlight some common mistakes to steer clear of, and share real-life examples, including what happens when things go right and when they go very wrong without a plan. By the end of this 15 to 20-minute episode, you'll have a clear roadmap for securing your financial legacy. Whether you're a retiree thinking about your family's future, a business owner planning to pass on the company, a professional accumulating assets, or anyone who cares about your heirs, there's something in this episode for you. So, grab a cup of coffee, get comfortable, and let's jump into Estate Planning 101. Why estate planning matters for generational wealth. Imagine spending your whole life building up your assets, your home, your savings, maybe a family business, only to have those hard-earned assets tied up in legal limbo or shrink in value after you're gone. Estate planning is about preventing that scenario. It's about making sure that what you have goes to who you want in the most efficient way so that your wealth can benefit your children, grandchildren, or other heirs for years to come. In simple terms, an estate plan is a set of legal documents and strategies that outline what happens to your assets when you die or if you become incapacitated. This typically includes a will and often other tools like trusts, powers of attorney, and healthcare directives to cover all the bases. A good estate plan safeguards your wealth, minimizes taxes, avoids family arguments, and handles personal matters if you're unable to. It puts you in control of your legacy, rather than leaving decisions to the courts or state laws. Now, you might say, I'm not super rich. Do I really need to worry about generational wealth? The answer is yes. Estate planning isn't just for millionaires or famous families. It's for anyone who has something to leave behind. In fact, it's often even more critical for families of modest means, because you want to make the most of what you have. Every family, regardless of wealth, can benefit from a sound estate plan. It's not only about money either. It's also about personal wishes, like who would care for your minor children, or even your pets, and reducing stress for your loved ones. Without a plan, you lose the ability to make these important decisions. And what happens? The state's default rules kick in. That means a court, following state law, will decide who inherits your property. The outcome might not be what you intended. In a worst-case scenario, if no eligible relatives are found, your hard-earned assets could even end up going to the state. No one wants that. Good estate planning can literally make or break a family's financial legacy. There's an old saying, shirt sleeves to shirt sleeves in 3 generations. It reflects a harsh reality. Without guidance, wealth often dissipates over time. In fact, about 70% of wealthy families lose their wealth by the 2nd generation, and 90% by the 3rd. Why does this happen? Sometimes heirs aren't prepared or responsible. Sometimes there's infighting. Sometimes estate taxes and legal costs eat into the wealth. But a big factor is the lack of a solid estate plan and communication. A well thought out plan can buck this trend by setting rules and structures for how wealth is managed and passed down. Let's look at a dramatic example from history. Consider the Vanderbilt family, once one of the richest families in America. Cornelius Vanderbilt built a shipping and railroad empire in the 1800s, amassing a fortune equivalent to $105 billion in today's dollars. Yet, just a few generations later, that fortune largely vanished. By 2019, his descendant, CNN's Anderson Cooper, inherited a mere $1.5 million, essentially nothing compared to the past wealth. What happened? While the full story is complex, a key factor is that the Vanderbilts lacked a strategic, long-term estate plan to protect their assets. Without strong guidance, some heirs spent lavishly, and family infighting further drained the wealth. In contrast, look at the Rockefeller family. John D. Rockefeller, another Gilded Age tycoon, took steps to ensure his wealth lasted. The Rockefellers used trusts to hold most of their assets, preventing future generations from squandering the money. Those trusts also kept assets out of the taxable estate, meaning Uncle Sam wouldn't take a huge bite in estate taxes, and the family set up business succession plans and charitable foundations that continue to this day. Thanks to this foresight, the Rockefeller legacy endures, and their wealth has benefited multiple generations and society through philanthropy. You don't need to be a Vanderbilt or Rockefeller to apply the lesson. Planning ahead is essential. Whether your estate is worth $100,000 or $100 million, estate planning can help preserve the wealth you've built so it doesn't evaporate due to avoidable mistakes. It ensures your values carry on with your assets. For example, you can include charitable bequests or set up trusts that encourage education or prudent financial habits among your beneficiaries. The bottom line is this: estate planning gives you peace of mind and control. It's an act of care for your family's future. By taking time now to plan, you're potentially saving your loved ones from years of legal headaches, tax burdens, or conflicts down the road. As we'll see in some real examples coming up, not having a plan can lead to costly, painful outcomes, whereas having a good plan is one of the best gifts you can leave your heirs. Key estate planning tools and strategies. Let's turn to the tools and strategies that make up an estate plan. Estate planning might sound technical, but the core tools are actually pretty straightforward. We'll break down 4 of the most important ones: wills, trusts, tax-efficient wealth transfers, and ways of avoiding probate. Understanding these will give you a solid foundation to protect your wealth for the next generation. Wills, the foundation of your estate plan. A last will and testament, usually just called a will, is often the cornerstone of an estate plan. In a will, you spell out exactly who should get your assets when you pass away and who will manage your estate, the executor. You can also name guardians for your minor children in a will. Very important if you have kids under 18. Think of a will as your voice after death. It's a legal document that tells the world your final wishes and instructions for distributing your property. For example, you can state, "I leave the house to my daughter and my investment account to my 2 grandchildren equally," and so on. Without a will, you're considered intestate, meaning the state law decides who gets what, and it may not align with what you wanted. Wills are relatively straightforward to set up with the help of an attorney, and almost everyone should have one. However, a will by itself does not avoid probate. We'll talk more about probate in a moment. The will actually goes through probate court for validation when you die. Still, having a will is far better than nothing. It generally makes the probate process smoother because your wishes are clear, and it reduces the chance of family fights over who gets what. In your will, you also nominate an executor, sometimes called a personal representative, who will be in charge of carrying out your instructions. Choose someone responsible and trustworthy for this role, because they'll handle tasks like paying final bills, filing taxes, and distributing assets. One common mistake is appointing the wrong person as executor or trustee, which can lead to conflicts or mismanagement. So think carefully about who is best suited. Ideally, someone level-headed, who can handle paperwork and potential disagreements calmly. It's worth noting that some assets cannot be given by a will. For instance, accounts or insurance policies where you've named a beneficiary, like a life insurance policy or a retirement account, will go directly to the named beneficiary outside the will. Similarly, property you own jointly with right of survivorship, say a house owned jointly with your spouse, typically passes directly to the surviving co-owner. We'll discuss this more under probate, but the key point is keep your beneficiary designations updated on things like 401ks or IRAs, and make sure they fit with your overall plan. If your will says everything to my son, but your IRA still lists your ex-spouse as the beneficiary, that IRA is going to the ex-spouse because beneficiary designations usually override a will. Coordination is key. Trusts, powerful tools to protect and transfer wealth. Next up, trusts. Trusts are often seen as a complex or high-end tool, but in reality they can be extremely useful for many families, not just the very rich. At its core, a trust is a legal arrangement where you, the grantor, transfer assets to a trustee to hold for the benefit of someone, the beneficiary. Think of a trust like a special box or bucket in which you place certain assets. The trustee holds the handle of that bucket and manages it according to rules you set for the benefit of your chosen people. Trusts come in different flavors, but let's focus on a common one for estate planning, the revocable living trust. A living trust is established while you're alive, hence living, and is usually revocable, meaning you can change or cancel it at any time while you're alive. Why do people use living trusts? One big reason: to avoid probate. Assets that you transfer into a properly set up living trust bypass the probate process and go directly to the beneficiaries according to the trust instructions. For example, you could have a living trust that says, while I'm alive, I'm the trustee and beneficiary of my own assets, so nothing really changes in how I use my money. Upon my death, my daughter will become trustee and continue to manage the assets for the benefit of my grandchildren until they reach age 25, then distribute the assets to them. That kind of arrangement would mean when you pass, the trust assets don't get stuck in court. The successor trustee, your daughter in this example, can immediately follow the plan. Privacy is another benefit. Unlike a will that becomes part of public court records, a trust is private. No public disclosure of what assets you had or who got what. Trusts are also very flexible. You can set conditions or protect beneficiaries in ways a will cannot. Want to prevent an heir from blowing through their inheritance in a year? A trust can stagger distributions or allow the trustee to dole out funds as needed for, say, education or buying a first home, rather than handing over a lump sum. Trusts can protect assets from creditors or even from an heir's own poor decisions. For example, the Rockefeller family used irrevocable trusts, a type of trust you generally can't change, once set up, to prevent wasteful spending and preserve their fortune for future generations. When done right, such trusts not only keep spendthrift heirs from draining the pot, but can also keep those assets out of the reach of estate taxes. If you have a family business or property, trust can ensure those stay in the family line or are managed by the right people. There are also specialized trusts for specific goals. For instance, charitable trusts if you want to leave a philanthropic legacy, or special needs trusts to provide for a disabled child without affecting government benefits, etc. It's important to highlight, setting up a trust is one step. Funding the trust is the crucial follow-up. Funding means transferring ownership of assets into the trust's name. If you create a living trust but forget to retitle your house or bank accounts into the trust, those assets won't be covered by the trust and could still go through probate. A common mistake is not funding a trust properly after creating it, essentially leaving the bucket empty or half filled. Make sure to work with your advisors to move assets into the trust, or name the trust as beneficiary where appropriate. Trusts, especially living trusts, aren't necessary for absolutely everyone, but they are extremely useful for a lot of people. For example, if you own real estate in more than one state, a living trust can avoid multiple probate processes. If you have minor children, you might use a trust to hold assets for them until they're old enough. If privacy is a concern, or if you want to manage how and when your heirs receive funds, trusts are the way to go. They can sound intimidating, but think of it this way. A will says who gets what. A trust can say who gets what, when, and how. Tax-efficient wealth transfer, don't give more to the IRS than you must. Another key aspect of estate planning is making sure taxes don't erode your wealth unnecessarily when it passes to the next generation. This primarily concerns the estate tax and gift tax at the federal and possibly state level. Now, depending on your net worth, estate taxes may or may not be an issue. Currently, as of 2025, the federal estate tax only kicks in for estates larger than about $13.99 million per person, almost $28 million for a married couple with proper planning. That means many families won't owe federal estate tax under the current law. However, this threshold is scheduled to drop roughly in half after 2025, back to around 5 to 6 million, adjusted for inflation, unless laws change. Moreover, some states have their own estate or inheritance taxes with lower exemptions, which could affect moderately wealthy estates. And if your estate is above those exemptions, the tax rate can be hefty. The federal rate is 40% on amounts above the threshold. The last thing you want is for a big chunk of your lifetime of savings to be lost to taxes if there are legal ways to reduce that bite. So, what are some tax-efficient wealth transfer strategies? One fundamental strategy is gifting during your lifetime. The IRS allows you to give a certain amount each year to as many people as you want, free of gift tax. This is known as the annual gift tax exclusion. In 2025, that amount is $19,000 per recipient per year. For example, if you have 4 children, you could gift each of them $19,000 every year, and if you're married, you and your spouse could each give $19,000 to each child, which effectively doubles it. These gifts reduce the size of your estate, thus potentially reducing future estate tax, and let your kids or grandkids benefit now. In fact, giving assets while you're alive has a dual benefit. You get to see your loved ones enjoy the gift, and any growth on those assets from now on happens in their hands, not yours, meaning that growth isn't adding to your taxable estate. For instance, if you give stock to your child now, and it doubles in value over the next decade, that increase is in your child's estate, not yours. Beyond annual gifts, there's also a lifetime gift and estate tax exemption, the approximately $14 million mentioned earlier. You can use that to give larger sums either during life or at death without tax, up to the limit, though large lifetime gifts require filing a gift tax return to track usage of your exemption. More advanced tools include trusts designed to minimize taxes. For example, irrevocable life insurance trusts, ILITs, can keep life insurance payouts out of your estate, Charitable trusts can give you tax deductions and remove assets from the estate while benefiting a charity and your heirs. Another strategy for those with very large estates and charitable intent is setting up a charitable foundation or donor-advised fund, which can create a legacy of giving and also confer tax benefits. For business owners or owners of appreciating assets, there are techniques like family limited partnerships, grant or retained annuity trusts, GRATs, and other vehicles that leverage valuation discounts or freeze asset values for tax purposes. Discussing all of these is beyond our scope today, but the key idea is estate planning isn't just about who gets what. It's also about doing it in a tax-savvy way so that more of your wealth ends up with your family and less with the government. If you're in a range where estate taxes could bite, definitely get advice on strategies to minimize those taxes. Even if you're not super wealthy, pay attention to income tax implications for your heirs. For example, certain assets get a stepped-up cost basis at death, which is good for heirs, as it can eliminate capital gains on appreciation, whereas retirement accounts inherited by your kids may be taxable to them as income. A financial or tax advisor can help structure things for tax efficiency. To sum up this part, through smart planning, using gifting, trusts, and charitable or other vehicles, you can pass on wealth in a way that legally reduces taxes. For many, simply maximizing use of tax exemptions, annual gifts, the lifetime exemption, etc., and proper titling ownership will do the job. The result is that your heirs keep more and can enjoy the fruits of your legacy instead of losing a large percentage to estate taxes or probate costs. Avoiding probate, saving time, money, and privacy. We've mentioned probate a few times, so let's explain it and why avoiding probate is often a goal of estate planning. Probate is the legal process by which a court validates your will, if you have one, and oversees the distribution of your estate after death. If you die with a valid will, probate is generally simpler. The court essentially ensures the will is followed. If you die without a will, intestate, probate tends to be more complicated. The court must identify your legal heirs according to state law, appoint an administrator, and supervise how your assets are divided. Either way, probate takes time and can be costly. It often involves court fees, and if lawyers are needed to help, there are legal fees as well. Some states even allow lawyers and executors to collect a percentage of the estate's value as a fee. Plus, probate filings are usually public record, so the size of your estate and who inherits can become public information. For example, when the musician Prince died in 2016 with no will or estate plan at all, his estate, worth an estimated $200 million, went into a lengthy probate process. He had no spouse or children, so under state intestacy law, his siblings were identified as heirs. What followed was years of legal battles, multiple lawyers, disputes over estate valuation, and even some alleged relatives coming out of the woodwork. It took about 5 to 6 years and many millions in legal fees to finally settle Prince's estate and distribute assets to his siblings. In the meantime, 2 of those siblings died before things were resolved. This is a high-profile example of the nightmare probate can become when there's no plan. The estate also had to deal with hefty tax issues. The IRS and estate eventually agreed on a value of $156 million, and significant estate taxes were owed. By the end, a sizable chunk of that wealth went to taxes and fees, not to mention the delay in the heirs actually receiving their inheritances. All of this reinforces why avoiding an unnecessary probate ordeal is worthwhile. So, how do you avoid probate? The basic idea is to die with as few assets in your name alone as possible. Assets that are in a living trust avoid probate. The trust doesn't die when you do, it just carries on under a new trustee. Assets that have designated beneficiaries, like life insurance, IRAs, 401ks, some bank accounts with POD, payable on death designations. Bypass probate and go straight to the named beneficiaries. Jointly owned property with right of survivorship, like a joint bank account or joint tenancy real estate with a spouse, will pass to the survivor without probate. Many states allow a transfer on death, TOD, or payable on death registration for things like securities accounts and even real estate or vehicles, which means you can name a beneficiary and treat it similar to a life insurance payout. No court needed. The asset goes to the named person upon showing a death certificate. By using a combination of these tools, you can ensure most of your property doesn't require probate to transfer. For instance, you might put your house and investment accounts in your living trust, keep your retirement account beneficiaries up to date, and own cars, jointly with a spouse or in TOD form. Then there's very little that has to go through the will probate, maybe some personal items or residual things. And even those the will can often pour into the trust through a pour-over provision. Why is this good? It saves your heirs time and money. Instead of waiting perhaps 6 months, a year or more for the court to approve everything, they can often access what you left them within weeks. It also maintains privacy. No public court record means nosy neighbors or fraudsters won't easily see what your widow or kids inherited. And it can avoid multiple probate processes. If you own property in more than one state, your estate might have to do probate in each state, called ancillary probate. But if those properties are in a trust, no separate court proceedings needed in each location. Now, avoiding probate is generally beneficial, but it's not the only goal. For small estates, probate may be quick and simple via shortcut procedures. Some states have streamlined probate for estates under a certain value. However, for substantial assets or any complex situation, planning to minimize probate is wise. It's especially important if you have real estate, a business, or assets that your heirs will need to access promptly. No one wants their family dealing with a legal quagmire while also grieving. In summary, probate equals time, cost, and loss of privacy. A well-crafted estate plan will use wills and other mechanisms, trusts, beneficiary designations, joint ownership, to streamline the transfer of assets. When done right, your family can avoid the delays of probate and receive what you intended for them with minimal hassle. This ties back to our big theme. Protecting your wealth for the next generation isn't just about how much you leave, but also how you leave it. Avoiding a probate court drain is part of that protection. Common estate planning mistakes and how to avoid them. Estate planning is incredibly beneficial, but it's easy to make mistakes if you're not careful. Let's go over some common pitfalls people encounter in estate planning, and more importantly, how to avoid them. By sidestepping these mistakes, you can ensure your plan truly achieves what you want and doesn't backfire. Here are several of the most frequent estate planning mistakes: procrastinating or not having a plan at all. The number one mistake is simply putting off estate planning. It's understandable. Thinking about death or incapacity isn't pleasant, and people tend to delay it. But none of us knows what tomorrow holds. Sadly, most Americans die without a will. In one survey, over 40% of people without a will said they're waiting until a health scare or diagnosis to make one. A risky game, because by the time a crisis hits, it might be too late, or you might not be mentally capable of creating a valid plan. The result of not planning is, as we discussed, intestacy, meaning your loved ones could face long court proceedings and your assets may not go where you'd want. The fix: make it a priority. As one estate planning expert put it, you can never make an estate plan too soon because you can't know when it might become needed. Even a basic will and power of attorney is better than nothing. If you're listening right now and you haven't done any estate planning, consider this your friendly nudge to get started. It's an act of love for those you care about. And if you have started, great. Just be sure to keep your plan updated. More on that in a second. Failing to update your estate plan. Over time, life isn't static, and a good estate plan isn't set it and forget it. One common mistake is forgetting to update your will or beneficiaries when major life events happen. Things like marriage, divorce, the birth of a child or grandchild, or acquiring significant new assets should all prompt a review of your plan. If you don't update, you might unintentionally leave someone out or leave in someone. Imagine forgetting to remove an ex-spouse as the beneficiary on a life insurance policy. Yikes. Even without major events, it's wise to review your estate plan every few years. Tax laws change, asset values change, and your own wishes might evolve. For example, the federal estate tax rules we discussed are slated to change after 2025, which might warrant adjustments if your estate is near the taxable range. Another scenario, let's say you move to a different state. You'd want to ensure your documents still comply with that state's laws. Or maybe your chosen executor or trustee has aged or is no longer the best choice. Update your documents to name a more appropriate person. The fix. Schedule periodic checkups on your estate plan. Many recommend every 3 to 5 years or whenever a big life change occurs. Keep a list of your assets and accounts and update beneficiary forms. An outdated estate plan can sometimes be almost as problematic as not having one at all, so keep it current. Not coordinating beneficiary designations and asset titling with your plan. We touched on this earlier, but it's worth emphasizing. People often assume their will covers everything, but certain assets pass outside of the will, notably retirement accounts, life insurance, annuities, and any account or property with joint ownership or TOD/POD designations. A classic mistake is forgetting to update those beneficiary forms or not naming contingent backup beneficiaries. If your primary beneficiary predeceases you and you didn't name a contingent, that asset might end up in probate or going to someone by law that you didn't intend. Another mistake is mismatched titling. For example, your will says, "Split everything equally among my 3 kids," but you had added one child's name as joint owner on a bank account to help you pay bills. That account will legally pass entirely to that one child at your death, not split with the others. That could cause an unintentional disinheritance or at least family discord. To avoid this, do a thorough review of all your accounts and property. Make a list of every asset and how it's owned, solely, jointly, in trust, and who the beneficiary is, if applicable. Ensure this matches what your overall wishes are. If you set up a trust, remember to fund it, transfer assets into it. An unfunded trust doesn't accomplish much. Also, name alternate beneficiaries on accounts where possible. Coordination between your will or trust and your asset titles is key to a smooth plan. Choosing the wrong executors, trustees, or agents. Another frequent pitfall is not being careful in selecting the people who will carry out your plan. For instance, you might feel obligated to name your oldest child as the executor by tradition, but if that child is disorganized or easily influenced by others, it could spell trouble. An executor or trustee should be responsible, impartial, and willing to do the job. If you name 2 siblings who don't get along as co-trustees, expect delays and fights. If you name a close friend who knows nothing about finances, they might bungle asset management. And always ask people for permission before naming them. Being an executor or trustee is a significant duty, and surprises are not good here. Similar caution goes for who you name as power of attorney to handle your finances if you're alive but incapacitated, or healthcare proxy. Many estate plans include these documents too, and naming someone who is bad with money or too emotionally conflicted to follow your wishes can defeat the purpose. The fix. Pick the right people for the right roles. Sometimes it's even wise to choose a neutral third party, like a professional fiduciary or trust company, especially if the estate is large or complex or family dynamics are tricky. The success of your plan rests on the execution, so choose executors, trustees who are competent and trustworthy. And as mentioned, keep those choices updated if circumstances change. Trying to DIY complex estate planning. We live in a DIY era with lots of online forms and tools, and while it's possible to draft a simple will on your own, going solo can be a mistake if your situation isn't straightforward. Estate law can be nuanced, and each state has different requirements for wills and trusts. Documents with errors or that don't meet legal formalities can be invalid or cause confusion when the time comes. For example, if a will isn't witnessed properly, it might be thrown out. If a trust is worded ambiguously, beneficiaries could end up in court fighting over the meaning. Also, do-it-yourself plans might fail to account for special circumstances, like having a child with special needs, a blended family with stepchildren, or a family business. The fix: when in doubt, consult an estate planning attorney or qualified professional. They can ensure your documents are sound and tailored to your needs. Yes, there's a cost, but it's often a worthwhile investment to save far greater expense and heartache later. As Kiplinger reports, many attorneys will even offer a flat fee for basic estate plans, and free consultations are common. If you have a very simple estate, online templates might suffice, but be honest about your situation's complexity. And even if you start with a DIY will, consider having a pro review it. Essentially, don't let small savings now cost your family big later. Lack of communication and family preparation. Lastly, an often overlooked mistake is not discussing your estate plan, at least in general terms, with your family or heirs. You don't necessarily have to reveal dollar amounts or give copies of your will to everyone, but letting your chosen executor and key family members know that you have a plan and what your basic wishes are can prevent a lot of shocks and conflicts. Too often, heirs are caught completely off guard by what's in a will. Surprises can lead to disputes or hurt feelings. For instance, if one child is left a different share for a good reason, maybe you paid for their education or gave them a start in business earlier, explaining that in advance or in a letter can help them understand your reasoning. If you've named someone to make healthcare decisions or as power of attorney, make sure they know and are willing. Also, make sure your documents can be found when needed. If you hide your will in a safety deposit box and no one can access it, it's a problem. A mistake here is locking up documents without telling anyone how to get them. The fix: communicate and organize. Keep a master file of your estate documents and tell a trusted person or your executor where it is. Provide copies to your executor trustee and perhaps to primary beneficiaries if appropriate. Have a family meeting or at least a conversation with loved ones to set expectations. As uncomfortable as that might be, it can stave off a lot of confusion later. Remember, clarity is a great gift to leave your family. By being aware of these common mistakes and taking the steps to avoid them, you'll greatly enhance the effectiveness of your estate plan. In estate planning, an ounce of prevention is worth a pound of cure. It's much easier to set things up correctly now than for your family to fix problems later when you're not around. So plan early, update regularly, coordinate everything, choose good people, get help when needed, and communicate your wishes. These actions will help ensure your wealth truly stays protected for the next generation. Real-life examples: estate planning, successes and failures. To really drive these points home, let's discuss a couple of real-life case studies from the industry, one demonstrating the consequences of not having a proper plan, and another showing a successful estate planning outcome. We've already touched on a few famous names, but now we'll frame them as lessons that we can learn from. Case Study 1, The Cost of No Plan, Prince's Intestate Estate. We already recounted the saga of the legendary musician Prince, but it bears summarizing as a cautionary tale. Prince passed away suddenly at age 57 with no will, no trust, nothing in place. He was a mega celebrity with an estate estimated around $200 million, yet all that wealth didn't come with an estate plan. What happened? A judge had to step in to sort out who his heirs even were, since Prince wasn't married and had no children. Ultimately, his sister and 5 half-siblings were deemed the heirs under law, but not before a woman came forward claiming to be his secret wife, and someone else claiming to be his child, among others, complicating the process. Because there was no will, everything went through a long, public probate. The proceedings dragged on for years. In fact, it took about 6 years to finally settle everything. During that time, millions of dollars were spent on legal fees, court costs, and valuation fights, which directly diminished the estate's value for the heirs. Prince's estate also got hit with a big tax bill after the IRS and estate administrators negotiated. About $156 million was left to split, meaning roughly tens of millions had gone to federal and state taxes along the way. To pay those taxes and fees, his estate likely had to sell or monetize some assets. And because all this was public, it was splashed across headlines, which is probably not what the intensely private artist would have wanted. The lesson from Prince's case, and similarly from other celebrities like Aretha Franklin or Jimi Hendrix, who died without wills, is clear. If you don't decide, the state will decide for you, and it may not be pretty. It's tragic because all of this could have been prevented with some basic planning. A will could have named his beneficiaries and an executor to take charge. A trust could have kept it private and efficient. Tax planning might have saved tens of millions. Instead, we got a textbook example of how dying intestate leads to chaotic and emotional, not to mention very public, battles for the loved ones left behind. Even if you're not dealing with rock star amounts of money, the proportional effect is similar. No will can mean a long probate for your family, more legal costs, eating up perhaps 5% or more of the estate in fees, which for a $500,000 estate is $25,000 plus, and potential family rifts. So don't be like Prince in this regard. Make sure you have the core estate planning documents in place. It will save your family a lot of trouble and preserve your wealth from unnecessary erosion by taxes and lawyers. Case Study 2, Successful Planning, the Rockefeller Legacy. On a more positive note, let's revisit the Rockefellers as an example of how proper estate planning can secure a legacy across many generations. John D. Rockefeller, who became America's first billionaire in the early 20th century, was very intentional about passing on his fortune. He and his descendants made extensive use of trusts to hold family assets. By placing assets in irrevocable trusts, the Rockefellers achieved several things. The assets were managed by trustees according to clear terms, so no one heir could go rogue and squander the lot. The wealth was protected from creditors and divorces, and importantly, those trust-held assets were kept out of the estate tax cycle, meaning each generation didn't have to pay a huge estate tax as the wealth moved down. They also set up structures for business succession so that family businesses or investments would be capably managed even after the founders were gone, and embedded philanthropic goals. Indeed, the family created foundations like the Rockefeller Foundation that still exist today. The result? Over 100 years later, the Rockefeller family is still known for its wealth and influence. While the fortune is now spread among many descendants and much has been given to charity, the family as a whole has largely avoided the shirt sleeves to shirt sleeves fate through intentional planning. Another example in the same vein is the Mellon family. Think Andrew Mellon, the banker high-share industrialist. The Mellons also used trusts and careful planning to encourage each generation's success. As of a few years ago, the Mellon family had maintained an estimated $12 billion fortune since Thomas Mellon's death in 1908. That's over a century of preserving wealth. Their estate plan not only preserved assets, but also encouraged entrepreneurship in the next generation through controlled investments, showing that an estate plan can incorporate values and not just dollars. Now, most of us won't have the complexity of a Rockefeller-level plan, but we can apply the same principles on a scale that fits our situation. The lesson from these successful cases is that proactive planning works. By using the right tools, like trusts, and thinking ahead about issues like spendthrift heirs, taxes, and who should be in charge, you can create a legacy that endures. Even on a modest level, suppose you have a vacation cabin you want to keep in the family. A little planning, maybe putting it in a trust or LLC and leaving instructions funds for its upkeep, can ensure your great-grandkids get to enjoy it instead of it being fought over or sold off. Or if you have a small business and you want it to continue after you retire or pass on, you can set up a succession plan, maybe involve your children gradually, or arrange for a key employee to take over with a buy-sell agreement funded by insurance. These are all estate planning in action too. It's not just documents, it's planning for the future stewardship of what you built. To bring it to a relatable scale, consider a hypothetical successful estate planning scenario. Jane and John are a couple who built a profitable family restaurant over 30 years. They also own a home and have savings. They have 2 adult children, one who is active in the business and one who is not. If Jane and John do nothing when they pass, their children might disagree on what to do with the restaurant. Sell it? Who gets it? And the business might even falter during the transition. But Jane and John instead work with an estate planner. They create a plan where a trust owns the restaurant and stipulates that Child A, who runs the restaurant, can buy out Child B's share over time at a fair price, perhaps using life insurance proceeds or a payment plan. So each child is treated equitably. They place their home in a trust or add a TOD deed, so it passes to the kids without probate. They update their wills to pour any miscellaneous assets into the trust. They also set aside some funds in the trust to provide liquidity, cash, so that estate expenses or taxes can be paid without forcing a sale of the business. When Jane and John eventually pass, the transition is smooth. Child A continues running the restaurant per the plan. Child B receives other assets or payments, so they're satisfied, and the home and savings transfer directly. There's no probate delay on the restaurant or house, and minimal chance of a family feud because everything was discussed and laid out in advance. The business they poured their life into continues thriving and generating wealth for the family rather than being lost or sold off at a discount. That's a successful estate plan in action. It protected their wealth, the business and home, honored their wishes, and kept family harmony. In short, real-world outcomes underscore that estate planning, or the lack of it, has real consequences. Failing to plan can lead to long legal battles, high costs, unnecessary taxes, and broken family relationships. We see it happen all too often, from celebrity estates to everyday folks. On the flip side, good planning can save money, preserve, and even grow assets over generations, and provide for a much happier legacy. It can literally be the difference between your family thriving financially or struggling after you're gone. As we wrap up, keep these examples in mind. They're powerful reminders of why we go through the effort of estate planning in the first place. Conclusion: estate planning might sound complex, but at its heart, it's really about love and foresight. Love for your family and the foresight to put things in order for their benefit. Today we covered a lot of ground. Why estate planning is so important. If you don't take control, someone else will, and it might not end well. The key tools like wills, trusts, and tax strategies that can protect your wealth, the common mistakes to avoid, and some real examples that highlight the stakes. The takeaway is that estate planning is one of the most important steps you can take to secure your financial legacy and provide for the people you care about. A few final thoughts and actionable tips as we close. First, start now. If you haven't done any estate planning yet, even writing down your wishes and contacting an estate attorney or using a reputable online service to draft a basic will is a great first step. If you have started, review your plan regularly and update it as needed. Make sure to communicate with your family, or at least with the individuals who will carry out your plan. Don't leave them in the dark. Organize your documents and let someone know where to find them. Check your beneficiary designations on retirement accounts and life insurance. Do they reflect your current intent? If not, update them. Think about the legacy you want to leave, not just the assets, but any values or instructions. For example, some people write an ethical will or letter to share personal messages alongside the legal documents. And importantly, seek professional guidance for complicated matters. It can actually save money in the long run by doing things correctly. Remember, estate planning is not set in stone. It's a plan you can adjust over time. The crucial part is to have the plan in place. As the saying goes, hope for the best, but plan for the worst. We all hope to live a long life, and maybe even spend a good chunk of our money enjoying retirement. You earned it. But planning for the what if ensures that, no matter what, your remaining wealth goes where you want and does what you want for your family. It's about creating a lasting legacy, one that can endure through generations, because you took the time to lay a strong foundation. Thank you for joining me in this conversation about estate planning. I know it's not always the lightest topic, but it is so vital. By making these concepts accessible and taking action, you're empowering yourself and your family's future. If you found this helpful, please share this episode with friends or family who might also benefit. Estate planning is something everyone should know about. In our next episode, we'll continue to tackle financial topics that matter to you. Stay tuned for that. Until next time, this is Dean Tellone, reminding you that the best way to predict your family's future is to plan for it today. Happy planning and take care.